We've got a couple of board members that are tied up in traffic with the storm damage. So we're going to hold off here for just a bit. Right. We need to work through the 100-word petition. And in addition to that, we're going to break for lunch at 12:30. So before lunch, we're gonna hear how the 100-word petition was put together. Item one. Item two is we're going to go through the list of what the board has heard that you folks believe or we believe needs to be in the 100-word summary that's not there. And number three is we're going to chat about the sequencing of the elements. And then we're going to break for lunch. Over lunch, we'll have a new suggestion will be put together for a 100-word summary revision. And then we'll take that up when we come back from lunch. Forgive my voice. Is that okay? Go forward. So it's yours.
All right, so there's obviously a lot of comment, so I do want to respond to several things. So first, I want to clarify when I said about the petition being similar, what I meant is it's covering similar topics. I recognize that it is not similar, right? There are noticeable differences, there are several differences, and the ones that when I was looking at it, the main topic differences that I noticed when I was looking at it were first that the petition today, in addition to all of the other things that we talked about last meeting, the petition today has a provisional ballot process that I interpreted as applying to everybody, not just prospective residents. I interpreted that as applying to everybody whose citizenship is not verified by the Secretary of State. The second was creating this process of obtaining unattainable documents, as they use. So like we've kind of heard, these documents that just the clerk's office or whatever happened, you are not able to obtain it. The third, it does really emphasize more on what is documentary proof of citizenship, documentary proof of citizenship. And then the fourth was this addition of criminal and civil penalties in the text of the constitutional amendment itself. So I focused in my drafting on that provisional ballot piece and that civil and criminal penalties piece, because in the while that documentary proof of citizenship, I can't say that phrase, there's a lot there that I was not sure could be captured in 100 words alone to say what are the different types and what the intricacies of it. So I tried to keep that more narrow and vague, like we did with the last one, at just saying required documents versus getting into any extraordinary detail with that. So I want to respond next to a couple of things throughout as well that I heard and kind of my rationale for what I did and why. As far as one of the comments, these are in no particular order as well. As far as whether or not the secretary decides who is or is not a citizen, I did not include that specifically because I thought that was a very nuanced issue that would be impossible to cover in 100 words. And to do that would be at the expense of a larger issue that would impact every voter on a regular basis, such as this provisional ballot piece, the ID piece that are in this, things like that. So that's really what I tried to focus on. With regard to the first sentence in my summary, the requirement to verify citizenship by showing birth certificate, passport for voter registration, the reason I kept that for voter registration in there, and the reason I had that in there is because the way that I'm interpreting the constitutional amendment is that, first, I don't believe that I'm going to rephrase this to avoid the double negative. I do believe that it applies retroactively. When I read the petition, I see in the text of subsection 5, registration requirements after December 18th, 2026 have to provide this documentary, there's the proof of citizenship, as I'm going to call it, when they're doing their registration. But for registrations that are currently in the qualified voter file, those registrations have to be reviewed by the Secretary of State. We do not necessarily, like, as I read this, we may not necessarily require a document be provided to us because subsection 2 says that the Secretary shall make every effort to obtain and use documentation and data from federal, state, or local authorities. And it goes on to say, for example, motor vehicle license information. So I interpreted that as with Michigan, we're very unique in that our qualified voter file and the driver's license information is both housed under the Secretary of State. Most other states do not do that. We are able at our own level to have specific information that may meet that requirement. For example, if you have an enhanced driver's license, not a real ID, an enhanced driver's license, that you have to provide proof of citizenship to get the enhanced. As I interpreted this, this could potentially allow us to just look at that and verify citizenship in that way. I could be wrong on that, but that's how I interpreted this. And that's why in that very first sentence, I left the phrase for voter registration and then coupled it later to specifically say require Secretary of State to review voter rolls to verify citizens, et cetera. I'm fine if we want to kind of combine that to clarify that a little bit more, to clarify that it's for new registrants, current registrants, these are the requirements. I think that makes sense, but that was why I specifically left that. I don't believe that it is accurate to say that every single person would have to re-provide a document, especially for new registrant or for current registrants, excuse me, because of that reason. In terms of saying the specific word provisional, the reason I didn't include the word provisional is because I'm not, we've kind of gone around even with other petitions as well, even in prior years. When it comes to the word provisional, I'm not 100% sure that voters know what the word provisional is, and that if you were to see the word provisional, would that suggest to the voter that they have to take some other step to do something before their ballot would count? So that's why I phrased it as prohibit counting ballots versus require voting of provisional ballot in that context. So that way it tells the voter, in order for your ballot to count, these are the steps that you're going to have to take. As far as the next piece, enforcement versus penalty, I specifically chose the word penalty based largely on two things. So first, when you're talking about criminal provisions, I've never heard criminal charges be referred to as like an enforcement mechanism in typically, so that's partly why. But when you also look at the dictionary definition of enforcement versus penalty, penalty under the Oxford Dictionary is defined as a punishment imposed for breaking a law, whereas enforcement is defined under Oxford as the act of compelling observance or compliance. So I don't view a criminal, a section in the Constitution that says you are subjected to a 5-year imprisonment as an act of compliance or forcing compliance as much as it's a punishment for not doing something. Same with that fine provision. The fine, the $1,000 fine and the 5-year, I don't view that as a mechanism to ensure compliance. That would be, for example, like a mandamus action in court or some other court action to compel compliance. Whereas a $1,000 penalty and a 5-year sentence in the words that they have used in this specific constitutional proposal are phrased as a penalty for non-compliance, not trying to force compliance. So that was why I used penalty versus any other type. If to the extent if we want to spell out those specifics to say like this would be $1,000 and or up to 5 years, I think there's that's fine if we want to spell that out as well. I'm fine with that. And then a couple of other things that I didn't include and my rationale for that. So the reason I didn't include discussion on the separate ballot issue, for example, as to whether or not we would have to have 2 ballots, would it be 1 ballot with federal election versus state and local election, is because it is too many unknowns. I don't know sitting here whether or not in 3-4 years, if this were to pass, if we would have 2 separate ballots, a federal only ballot versus a state ballot versus a both ballot, or if it would be a different way. I don't know that. That's something that has to be flushed out. So that was partly why I didn't include that. And then the other reason I didn't include, is for the same reasons why I didn't include anything about the poll lists or the language that they have in there that it must be generated from and consistent with the statewide qualified voter file, is because I don't know what the contents of that list would be that's different from what it is now. Like the law already requires that the poll list be generated from the qualified voter file. That's the electronic poll book. And the paper version of the electronic poll book. That's essentially what this is, as I read that. And Michigan election law currently mandates that the poll book be downloaded from the qualified voter file using that information, or in the case of early voting, it comes. My point is it all comes directly from QVF currently. So that's why I didn't include that, because I didn't view that as much of a change for the voter that the voter would see. And then finally, with subsection 3, there's a lot of discussion on like this notice provision. So the reason I didn't include that is very similar to other ones. It was a very nuanced issue that if we want to include it, I think we could, but then that comes at the expense of a topic that hits at every voter. So if we want to say anything like providing notification or something like that, we can. I didn't include it because this is one of those provisions that's very similar to the one we heard last time. There's still notice provisions in the prior constitutional amendment petition that we talked about last month. We didn't include some of that language, I think, for the same rationale with the 100-word summary. For that same reason. So that's everything on my list. I know that was also quite a bit. I am happy to, so where we go from here, I'm happy to answer any questions. I think what would be helpful as we're looking to redo or to adjust it would just to be what are the things that you've heard my explanations, right? What do you want? Like, what are the things that you think need to be amended or added and things like that? So like we usually do. So
So if we approach it that way, to my fellow board members here, and this is your opportunity, but I think one, if there's items here that we want to add into the 100-word summary, let's list those out. And two is I think we want to structure what order all of the pieces go into. So with that said, Vice Chair Gurwitz, would you like to take the first shot?
Right, so I think I agree with the ballot components that the fact that this requires verification of everybody's voting citizenship status needs to be front and center, and that it precludes voting where the verification has not occurred. I think that needs to be the focus of this, because the opportunity obviously to vote is important and people need to know whether they're going to lose it. And I think that could be combined with the requirement that a new registrant provide the information. So just one sentence, like a constitutional amendment to require the Secretary of State to verify citizenship of all voters. It would cover both the new registrants and the existing registrants. I think I understand the importance of the criminal penalties. It's just so hard to put it in there and to have anybody understand what they are, but I think that needs to be in there. And with regard to the precinct poll list, this was problematic to me, and I don't know necessarily what was intended, but where they say that the qualified voter file has to indicate whether, when, and how citizenship is verified, and that the precinct poll list also has to be the same essentially as the QVF. That suggests to me that a lot of information is going to be in the precinct poll list that it just might be really problematic. So, and I thought that was similarly, I thought it was something that people ought to know. But anyway, that Now, on the other hand, I think we could say eliminate affidavit alternative, blah, 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 for those without photo ID when voting, add requirement to provide photo ID or driver's license or partial social security number. That part, I think, that fits. And so what we need to do, I think, is to get to the point where we can describe accurately what this is doing with regard to both new and existing voters. So, and I'm really baffled by how to include something with regard to the criminal incident. Because I think it's a big issue, but very hard to describe.
Why I left it though.
Yeah,
Yeah, for that reason.
Right,
Yep.
I don't know, saying it succinctly doesn't convey very much, but it would be hard to convey it otherwise, because we're limited, obviously, in how to describe a really monumental proposal.
There's a lot to put into 100.
Right, it is a serious challenge.
Member Cummings.
I mean, I would like to see it in there if we can. And
Yeah.
I understand what you're saying. I think the fact that it's the first time that there will be anything in the Michigan Constitution that has a criminal or civil penalty to it, I think is very important. But I don't think we're gonna be able to say much other than including what you put in it. Subject violations to civil criminal penalty. I mean, that might be the most we can do. But I feel that's important to have in the summary.
The other one, I guess I would add to that is 5 years is a long time. This isn't getting your hand slapped and going to pick up sidewalks for 90 days. This is a very significant. If you put it on par with other crimes in Michigan,
And no statute of limitations.
and there is no statute of limitations, and I think somewhere in here that has to be put in, but
Just adding and
but I'm getting your input, not mine. So do you have anything else you would like to see in here? Is there anything else in the petition that needs to be?
not anything different than Ms. Gurwitz said. I do think we need to have upfront that the fact that it's affecting everybody. The 8 million, I don't know if we list the amount, but that this is,
8,148,345.
no, because it's gonna change.
Yeah, the only reason I wouldn't specifically say the number is because the second, so you print this
Right.
30 seconds later, so that, yeah.
8 million plus.
Mr. Cordes, do you have anything you'd like to add?
No, I have no additions. I am curious to see whether, when we talk about sequencing of this, whether we can, move up the Secretary of State review, of the voter rolls to verify citizenship closer to where we have the, requirements of new registration. That would be the only thing that I would say. But nothing that I would like to see new added to this.
I would only have one comment regarding the ad takeaway. I would agree with the petitioners that they had a very strong request to make that first sentence to provide that only U.S. citizens can vote. And I think that does factually state what this whole petition, that is the root of the entire petition, right?
It is, but isn't that already
Yeah, that's
True.
that is already true. So it's only
So it's reflecting
only
something
US
that exists
citizens
already.
verified by the Secretary of
Oh,
State,
okay.
right?
Yeah.
Yeah.
We're not adding, we're not creating something new with this petition. We're simply modifying a process that's already in place and a law that's already in place.
Yes.
That would be how you would view that sentence.
Correct. Yeah, current, both law both at the state and federal level already, prohibit or prohibit non-citizens from voting, and there are criminal penalties associated with that. So I would say that that is consistent with current law as it exists now. If it's something that's important to the board, I mean, we can find a way to add it.
No, if it exists now, there's no reason to, it would be an error to make this appear as though it were a new.
Arguably.
Your requirements are new and the penalties are new and the verifications are new, but the law itself is.
Correct. And typically when we've seen this a lot in recent years with election law requirements, especially when the last couple of petitions under election law where it's shifted existing statutory requirements to the Constitution. We've tried to focus on what is the change, just because again, you're limited with 100 words, right? It sounds like a lot, but it's not. It goes very quickly. So we've tried to focus on what are those changes that voters would see. And this has been both with 100-word summary for the petition as well as the ballot language. Like what's different, what's being done that's different. So like if it is a requirement where it's existing, but we're adding something new to it, like that's kind of what we have tried to focus on, at least in what the Bureau's presented.
All right.
So what's new is verification
Correct.
and what happens if you're not verified.
So that's why I tried to focus on that piece of it. Yes. But I will say, I think I have enough to, based off what you said, I see that somebody wanted, so I'm not trying to like cut anything off or anything like that, but yeah.
You would like to address us shortly, quickly?
Other state courts have interpreted the same language in Michigan's constitution as ambiguous when it says every U.S. citizen, and then it follows that that's just a floor and doesn't necessarily preclude non-citizens from voting. The case is Lacey versus City and County of San Francisco. The California court there said that that was ambiguous and didn't necessarily prohibit non-citizens from voting. And so that's why we think it's important to add this language at the very beginning that says only U.S. citizens can vote. That's the rationale behind that, to respond to that.
I don't know what you're talking about. Honestly, I don't know any judicial decision that says that the requirement that you when you register to vote, you certify under penalty of perjury that you are a citizen.
I just cited you the case.
Is there,
It's Lacey.
what is the ambiguity?
Well, I personally would agree with you, but that has not stopped courts from interpreting similar
Or
language.
a court somewhere.
I cited, yeah, one case, Lacey versus City and County of San Francisco. But that's the whole point behind the ballot initiative, is to ensure that only U.S. citizens can vote, and you
As
cannot
verified
vote.
by the Secretary of State.
Correct, yes. Thank you, sorry.
Thank you. Right, it is 25 after 12. We will break for lunch and return at 1:10. That gives 45 minutes. Is that enough for Mr. Brewer?
At your disposal, Mr. Chair.
Well,
I think he looks hungry.
I know he looks hungry, but if we give you 45 minutes for lunch, does that give everybody enough time? Yeah. Stand in recess until 1:10.
I will say we do, just before everybody gets up, we do need to clear the room when the board leaves. I was informed by Senate Police of that. So we'll reopen it, but when we come back on the record. Thank you.
Well, are these for us to keep, or do we have to turn them back in? In other words, we don't write on them, right? I know, I thought that, yeah. I kept on Christine. I signed your name to yours.
Not signing any petitions, especially this one.
Adam, I'm gonna bring us back into order while you're doing that. I'll bring us back into order while you're doing. Meeting is convened at 1:14. We have a draft rewrite on the 100-word summary. We're just waiting for copies here. Would, would you like to take the first?
Sure. Yes, I can read. So what I have drafted, I will say I already noticed there's at the top, we do need to clarify one thing, but it just involves the heading, not the 100 words itself. So, but after hearing everything, what I have drafted is as follows. Constitutional Amendment 2 requires Secretary of State to verify citizenship of existing registrants and remove non-citizens using documents in government records, and prohibit counting ballots from voters whose citizenship hasn't been verified unless voters show documents to Secretary within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternative for those without photo ID when voting. Require photo ID or driver's license or partial social security number to receive or vote absentee. Require hardship program for obtaining required documents at state expense. Subject violations to $1,000 fine and/or up to 5-year imprisonment. And that is exactly 100 words. I was able to, so I'll kind of talk generally about some of the changes specifically. So I did bump up the very first line. I took that, I think that was the third clause before, I bumped that to the first, and then also combined it with the new requirement to try to match up that this is what's happening with the existing, what the changes that we have to do for existing versus what has to be done for new registrants. And then coupling that with that 6-day provisional ballot period, as we know that word to be. I was able to just rephrase a couple of things slightly to be able to get in the $1,000 fine and/or up to 5-year imprisonment. Using those words, I used those words specifically because it took it almost directly from the text of the proposed constitutional amendment itself. That's why I chose imprisonment specifically. And then that middle one, the eliminate affidavit requirement, that clause remained the same. That was previously the first one, and that's now moved down. And that is essentially, I believe, all of the changes to the proposed language.
Thank you for doing that over lunch. I would open the floor to comments.
I would, change existing registrants to all registered voters. I don't think registrant is a very good word. But then I think if you say, excuse me, all registered voters, you don't need to say you don't need the phrase about new registrants. So, and one thing that I was thinking about before was the part about documenting. So if you take out the phrase about for new registrations require proof of citizenship, blah, 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 all the way up to eliminate. And you can add something about which I think is important, about documenting proof of citizenship in the qualified voter file and precinct poll list.
So just make sure I understand, you're suggesting take out for new registrations require proof of citizenship, that whole line, that whole
Right,
phrase?
because I think if you say to verify citizenship of all registered voters, that includes anybody who's registering in the future.
The only, so
And I was, so, the phrase to document whether, when, and how citizenship is verified in the qualified voter file seemed to me really important. And maybe I'm reading more into it than others are, but it's a way. And I think there was also some reference to in the proposal to the qualified voter file being a public record so that it would show this, and that all sort of fits together with the criminal penalty part, because they want to be monitoring every moment of the verification. So, I'm doing more than just suggesting language here, but I'm sorry.
That's
fine.
But I'm telling you why I think that part is important.
the only piece that I would say with that, I think that would require some other tweaks as well, because for new registrations, those may not come to us. And so if you're starting off that sentence to say requires Secretary of State to verify citizenship and go through all of that, new registrations, when they come in, will be handled, most of them lay at the local clerk level. So I wouldn't want to suggest that this is, trying to think of the best way to phrase it, that it's somehow putting the registration piece onto the secretary, because that's still, one thing could come to the secretary, but you still as a voter fill out your voter registration form, bring it to your local clerk, and you'd have to show your local clerk.
It's still the burden of the Secretary of State to verify.
That is accurate, yes. Yes, that is, yes.
So whatever they get from the local clerk, they have to be able to assure that the local clerk has gotten the citizenship documents.
Yes,
And,
that is.
we're just summarizing here. So the proposal says what it says about new registrants and existing registered voters.
Yeah, I mean, if that's something, if we want to eliminate that, we can, and replace it with something we can, if the board's okay with that. Yeah, so.
So strike from where?
Or new registrations up through eliminate. That makes sense to you that you put the new registrants and the newly registered voters and the existing together? Because the Secretary of State has to verify everybody.
I understand what you're saying.
Although I would also suggest though that what these folks are proposing is distinguishes new registrations, right? Is that accurate?
I don't think it does, actually. I mean, they have to provide verification, but then they're in the file and then the Secretary.
Yeah,
of
to your,
State
to
has
your point with how that reads, if they're just like if the Secretary of State has to verify even the new registrants, obviously you're leaving some, not necessarily leaving something out, but you're getting to the very end which is the Secretary has to verify regardless.
Has to verify everybody, so. New registrants verifying themselves is sort of encompassed within the Secretary of State verifying everybody.
Yeah.
right? Um, so, and then I would add, using documents in government records and document proof in the qualified voter file. I just think that's. I don't know how many words that is.
Um,
Could say some along the lines of using citizen provided documents or documents, government records, because you're kind of combining two things that are happening.
Then you're throwing in the qualified voter file too, which is going to make everybody stop. I don't know how you weave QVF into people presenting.
If I may make a suggestion. If you want to put something in there about documenting this, retaining this in QBF, I would not tie it with that first clause just because that's already a very long and it's already, if you're doing it this way, you are kind of combining two steps into one thing. And plus you've got the additional third with the 6-day post-election. I would almost put it as an additional clause. If you're striking the 4 new registrations clause from semicolon to semicolon, I would replace that right there and say something along the lines of require documentation of the whether, when, and how citizenship was verified in the qualified voter file. You know, and you obviously wordsmith that, but I would put it there if that's what you wanted. If that's the direction the board wants to go.
You have a logical split there already. You have new voter registrations require them to present proof of citizenship.
Right.
The Secretary of State is required to verify using QVF. Those to me are completely two separate.
I agree with that. That's why I put that in there. And I think that's for new registrations to have to show that proof, I thought was a bigger change for voters versus like that was why I put that in there and had them separate.
I think it's factually relating it. Mr. O'Keefe, you were up here a little while ago. Is that a fair rendition? That you are asking the Secretary of State to verify citizenship, but you are also specifying new voter registrations will require proof of citizenship as presented with documents by the voter, by the registrant. So what you're saying is, but they take a different form when you weave them together. I think they change. It changes the.
Yeah, I took that. So in the constitutional amendment itself, it's subsection 5 that says no individual may be registered to vote in elections for state or local office after December 18th unless they provide documentary proof of United States citizenship.
all registered voters. With about 101 words.
There was.
Hyphenated words are single words, right?
That's what I was looking to see if there was any way to kind of tweak a little bit. You could get rid of just right at the front, the word "to" and just say requires Secretary of State verify citizenship of all registered voters is probably what I would do.
You could say eliminate affidavit alternative for voters without photo ID. Is that the same thing?
So the eliminate affidavit alternative for those without voting, photo ID was essentially the provision that would eliminate that alternate in the Constitution and would require all voters to show their license
affidavit
or
alternative,
photo
yeah.
ID.
Or voters without photo ID instead of for those without photo ID when voting.
Yeah,
Say that
Said
one more time now.
yeah, so here it would be for, no, for voters without photo ID.
Oh, I see. Okay.
Sure of that.
You could do that as well. Yep.
That's replacing two words with one.
That was.
Oh my gosh.
Expertise is being done. I do think that too.
You want that?
What do you think? Yeah, I mean, we require Secretary of State to verify or just verify. Secretary of State verify.
You can leave it in because you're back.
No, I think there's something.
Yeah, we're, this, we added one. But then and eliminate affidavit alternative for voters.
You could put a semicolon after registered voters.
Okay.
And then you
Take out
could
the
remove the and put a semicolon after records.
Yeah, you could do that.
Verify all registered voters, semicolon, remove then citizens. Semicolon, that county ballots isn't been there.
Yeah.
Well, you're busy removing words. Let me ask you another question. Should we, in the spirit of the petition, which calls out US citizens, Did we, in the spirit of the petition, make that first to verify US citizenship? Top line. Well, I don't
They
know. I
wanna say
mean,
it,
you know, again, it's, is that important to what you're arguing? And again, I'm looking at your,
we're looking at your little badges and they don't say US.
Results from the.
It's kind of assumed, right?
It's good at any.
You only had 5 words and not 100.
so that doesn't matter to you either way.
I might have a recommendation.
Okay.
So you,
I might have a, like, if I can kind of tweet, I'll read it before we print it.
okay.
I don't know why I'm talking that low. I should probably talk into the microphone. Just realized, sorry. Hold up. Okay. 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 So kind of hearing a couple of things. So, and I'll print this out if this kind of makes sense, at least initially before we print. But so constitutional amendment to require Secretary of State verify citizenship of registered voters, remove non-citizens using documents and government records, prohibit counting ballots from voters whose citizenship hasn't been verified unless voters show documents to Secretary within 6 days post-election, document citizenship in voter rolls. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternatives for voters without photo ID. Require photo ID or driver's license or partial social security number to receive or vote absentee ballot. Require hardship program for obtaining required documents at state expense. Subject violations to $1,000 fine and/or up to 5 years and 5-year imprisonment. Should that be years?
How many words?
100 exactly.
Because I think what was the part about documenting?
I put document citizenship in voter rolls. I didn't use QVF specifically only because we use voter rolls elsewhere in that. And I think more people understand voter roll versus QVF.
Verify citizenship of all registered voters. Okay, so if we,
The only reason I took it out was just, I mean, we can,
right, but if
Yeah.
we have, do we have a semicolon after voters in that first phrase?
yes.
Okay, and then I think you could eliminate the and in front of prohibit.
I already did.
Oh, okay.
What if you did, in the, just need one more word, right? So if you did, instead of at state expense, what if you did require state funded hardship program, and that would get rid of at?
That would work.
Hyphenated. Yeah. required state funded.
Yeah,
No, I.
that's a good call.
Role player, baby.
Nice.
And if you could hyphenate most of it,
I'm sorry,
you
good
could
one.
hyphenate. most of
Yeah,
it.
that's right. State dash funded.
That's right. What does that make the new word count?
That takes it to
I didn't.
99, sorry, 99.
99, we can put another word in. Um,
Actually, there isn't. I actually would add one more word, only in the one clause where it says to vote absentee ballot, I would add the word "an." So it says to required to receive or vote an absentee ballot, and that would take us to 100. Yes.
Okay, I think at one point did you say, oh, right. When you have receiver vote, you need to have, yeah.
Yeah.
Okay, well, that's,
We took one out, we added one in, so you should still be at 100 words.
Yeah, that would be 100.
Do you, can you print that and we'll circulate it?
Yes.
And then
Yeah, I definitely would. I know that's a lot, so I definitely would recommend.
let's print it and circulate it and then we can
Yep.
invite the parties back.
I think we're getting there with. Gosh. Less sound.
I like having the printer. No, not you. No. I'm just going back to the days when we had to like run somewhere else to get a printer and it was awful.
Thank you.
Oh, thank you.
think either's fine. Oh, yeah.
Yeah, I think you're 5 years.
Years.
Who's that? I think it's plural.
My initial thought singular was only because it said.
Maybe another year.
Yeah.
Years. It sounds like it should be plural.
I think, yeah.
I'm not either, so if we want to make it years. If that does it, yeah. Find again.
No.
No.
We don't.
My husband is a criminal defense attorney. He speaks in terms of
I'll just say it when I read it again. Read again or? Yes. That's.
Good point. like a jobs program. Does everyone has a copy of the new printout? Folks all have it?
Oh. I don't think you printed the new one, but that.
I'll
Yeah, but-
lay it on the record specifically, and then when we have it.
Summary.
Yeah, the amendment.
I would say, if you want to say it,
Um,
I wouldn't.
I would like to give, before we vote, I will open the floor up if you would like to. You would like to, if you would like to address this latest final version,
We have nothing to add. We thank the board for their work and,
You're good with it?
yes, thank you. Yes.
okay.
Welcome.
Mr. Ziegler, you would like to speak? Go for it.
Thank you. So this, the board has just worked through this draft, and obviously I think it's an improvement. But I guess I would ask the board to again consider including this two-tier voting system. And the problem that this petition puts into the Constitution is that the Constitution will potentially be contrary to federal law. And if it is, and then we have this two-tier voting system, the very people that won't be able to vote in state elections, the only way to get this two-tier system out will prevent those people who can't vote in state elections from voting to remove the two-tier system so they can vote. It's kind of a catch-22, where without a mention of the possibility or the potential, which could very well come true, of a two-tier voting system, petition signatories will not be at all advised of that. And once it's in, it's kind of in and will be very hard to remove. So I would just ask the board to consider adding in that or something to the effect of that, just to apprise voters.
Two thoughts on that really quick. One is that that's a very complex model to present within this 100-word summary along with the rest of the items. It would be a complex item
Absolutely.
for a potential signer to contemplate. The second one is more of a just a question. Is what you're describing with this putting the Constitution in effect in violation of the federal Constitution is what I thought I heard you say?
No, more so federal law.
Okay.
If federal law, if the citizen verification requirements in this petition don't comport with federal law,
Oh, I'm sorry.
they couldn't apply to federal elections. So then we would have one track for federal elections and another track for just state elections.
Would that be something that would be subject to being dealt with in the court system if this were put on the ballot? I mean, is that outside of the purview of what we're doing here?
So I think that kind of gets back to the earlier point, like, short answer, I think partially yes. The reason, like, when I saw that is because it gets into that unknown for me. I don't know whether this would violate the federal law or the federal constitution or even any other state provision or anything like that. And I can't sit here and tell anybody when drafting a 100-word summary that this will violate another provision, because I don't think I have that clarity. And as far as the tier, it's kind of the similar hesitation is I don't know what will happen. Like, I don't know and only because the specific text of this proposal does not say that. That might be one of the things that happens, but it might not be. I don't know if we'll end up doing 2 separate ballots. I don't know if it will be 1. I don't know if it'll be 3. So that's the main reason why I didn't include it. Again, if it's something that's important, then we can figure out a way to remove something and figure out a way to wordsmith it that voters would understand what that means. But I think that's a difficult concept as well to explain in general. So that's kind of what's my thoughts.
Yeah, you could, as you pointed out, you could add in a simple line that says creates a two-tier voting process, but that would be a misleading statement to put into the summary.
And I agree, and I would urge perhaps the use of the possibility of a two-tier system. Because the issue here is, it's sort of the complexity of the issue is equal to the importance of the issue and how permanently it's going to be locked into the Constitution. And I guess I would add just one point is, maybe I misspoke. It's not necessarily that this petition would put federally unconstitutional language into the Michigan Constitution. It's more so that there would be an inconsistency, and then the federal law supremacy clause would kick in. So it wouldn't necessarily overrule, the court wouldn't be striking down sections of the Michigan Constitution. They would just be holding that federal law will not allow this section to apply to federal ballots. So we need two separate tracks going forward, if that makes sense. It's not necessarily.
That sounds like a lot of litigation in the future.
So
And-
that- but somewhere, I mean, the way that that could be addressed would be that the verification that is required here would be for state and local elections. But I'm not sure whether in terms of informing voters, I don't know that they would understand the difference between requiring this for state and local elections and for federal elections. So, but that would address, I believe, the concern that you're expressing, would it not?
I think so.
Right.
Adding in language, keying in that if this petition is adopted and it's inconsistent, and then we have this two-track system, part of the issue is the people who only are allowed to vote federal elections won't be able to vote on the next petition that comes down the line, trying to remove language that created this two-track system. So suddenly we'll have a smaller subset.
That is bringing even further complexity to an already.
I don't envy the
complex
board. It's a very
situation.
complex issue. I just think it's
We can't
important.
hyphenate that
We
many
could
words.
hardly do that in 100 words.
Yes,
But
give your name and spell it for
Yeah.
them.
Yeah,
My name is Fred Zolik.
Okay.
I'm with Citizens to Protect Voters' Rights. The board was sent this document by the proponents of the amendment. This came in your packets at some point. Their proposal presumes that this federal-only system will exist. They're under reporting, it says, our measures requires extra information about the progress of citizenship checking, including a breakdown between federal-only and all other types of registrations. They think this is the default setting, that we will have a two-tier system. They go on to say there's a state versus federal distinctions. We allow list maintenance activities for non-federal registrations to continue past the NVRA's 90-day cutoff.
Reading in the.
This is a document that the proponents,
this.
Sent to you last week.
Okay.
so they're telling you that their proposal has a two-tier voting system. It's not hypothetical or contingent. They're expecting that this is the new default.
Right, because they're expecting the SAFE Act is not going to get passed. Senate, right, but, yeah, I understand that.
Okay, thank you.
That it's, thank you, that's really helpful.
Could you spell your name? Do you mind?
Oh, I'm sorry. You don't know how to spell it? WSZOLEK.
Just as it sounds.
No, you're close. What is it? What if you did Secretary of State, state and local, verify, the state and local election, citizenship, all of it. Was that? Put it in, yeah. It doesn't bring in the two-tier structure. You have to infer that.
I don't think it. I mean, I know what you're gonna do, but I don't think it. Support voters. The two-tier.
Guess the question is whether, given what we have and the limitations that we
Well,
have,
that's.
we want to include this added.
It would make me more, my inference of that, if I just stopped at the library. Inference of that would be this, they only care if I'm a citizen, if I'm voting in state and local. Which interestingly enough is exactly the antithesis of that would move.
Can I jump in?
Yes, please do.
So, the hesitation I have with adding for state and local elections only to a specific place is that the text of the constitutional amendment in subsection 5 specifically says, if federal law allows, this requirement shall also apply to registrations to vote in federal elections. So, meaning like the ID requirements, the documentary proof of citizenship, et cetera. Now, granted, federal law may or may not allow that right now. That's kind of what I'm getting at with the unknown. But if federal law changes, then it's right. But if something changes, then this is no longer accurate of what is going to be for the voter. So that's the only hesitation. If you want to put something in that relates that says that this would apply to state and local, I think you just have to be careful, because I don't think it's accurate to say that we have to verify citizenship for state and local elections only, or remove non-citizens using documents and government records for state and local only. Like that may not be true at some point. So that's why we don't get into hypotheticals, because we don't know and we don't want to mislead. So that's my only hesitation. If you want to do something with state and local, it just has to be in the right spot, and it's got to be worded very carefully to not misrepresent what it is doing.
Well, if I'm hearing Mr. Ziegler correctly, his whole point is to call out the fact that this petition is in effect creating a two-tier voting system. That's what I hear you saying.
Or at least the possibility of one.
Okay, so the
which
possibility, but the point is you're
signatories
calling
should be-
out, this could create a two-tier voting system, whereas if we simply call out state and local, that is not the flavor, that's not the message that's coming through. The idea that we're creating a two-tier voting system has enough legs that it should stand on its own, I think. That's a simple statement. But it's also
It's
not
not
a
just-
true statement.
Not just the possibility, but the likelihood.
I would agree with that. Yes.
Yeah.
Based off of the proponent's own literature, appears to be a likelihood.
Yes,
That a likelihood. If
there's another chair right there. Come on up.
Board spent a lot of careful time parsing, considering what's actually in the proposal and the actual consequences. Whereas starting out with something that's if, we don't know. We don't know what that part will be and how it doesn't conflict with the Secretary of State's not removing a citizen. A person removed from the state rolls for not being a citizen is not eligible to vote in the federal rolls because they're still not a citizen. I mean, this is way stuff. And it's also this other proposal last month, you didn't put anything about, well, this could create a two-tier proposal.
I'm sorry, the other proposal, what?
There's nothing in this summary approved by this board last month on the other citizen-only voting that said, well, this might create a two-tier voting system. I just think when you have a task of 100 words, and maybe we should get the legislature to amend it and give
The
you
other
more room,
Proposal didn't create a
Right.
two-tier voting system.
and it requires citizen-only voting to vote in the state. Well, that's it. If you have
The other one-
citizen-only to vote in the state and you have to prove it, then anyway, the main point is when you say if, how can something that's an if go in a summary? Any summary on anything? This might happen, that might happen.
But
It doesn't belong there.
in terms of Mr. Fracasse's point, that you don't know what's going to happen, but you do know that unless something happens, this creates a two-tier voting system. It does it now, and you're going to have the two-tier voting system unless federal law changes.
And I might phrase it this way, this might be a helpful way to think about it, which is currently I am not aware of anything in Michigan law, whether constitutional or statutory, that could lead to a two-tier voting system. All of Michigan law is cohesive. It's an on and off switch. Either you're a voter or you're not a voter. This petition would create the possibility of that. So this would be a new thing in Michigan law where voters could accidentally, without being informed of it, create a new two-tier structure. And I think that's a distinction because it's not an intangible if. It's something which did not exist before, will now exist, which is the possibility that some people will not be able to vote in state and local elections.
That's a whole lot of lawyerly words.
No, but it's not, and my quote is that it's not a possibility, but a likelihood. No, it's a certainty that there's a two-tier system unless there's change in federal law.
I would agree with that.
Yeah.
Yes.
So that's the issue that,
Well, yeah,
that does seem important.
that's not, the argument he was making is
I'm
that
sorry?
the argument he just made is that we've gone from where it wasn't a possibility to where it is a possibility and not that it's a certainty. And I don't agree that it's a certainty.
I think my argument would stand as I stated it. I would
Well,
not like it
Stan,
restated.
I repeated it. I didn't restate it. It's if.
I have nothing else unless the board has a question or. Thank you.
Don't wander too far.
You don't want to help us anymore?
Mr. Brewer,
So on this point, subsection 4 clearly requires the Secretary of State to make a report every year on the distinguishing lists. It states it positively and affirmatively. It does not state it as a hypothetical. This proposal anticipates that there's going to be two lists. Otherwise, why would it require a report about those two lists? The other thing I would point out to you is that you're now debating a summary for the petition. You can revisit this issue if they submit enough signatures and it gets on the ballot. But as I've listened to this debate, I believe the summary has to disclose that this is going to create a two-tier system of registered voters in the state. They said it in their petition. They didn't say possibility. They said it.
so is tier the right word? Is there another word that,
I was going to recommend something different because that doesn't suggest to me, like if I'm even sitting here, I'm struggling to understand what it means to say two-tier voting system. Like, I don't understand that phrasing. Like, I think the idea is to get at this fact, kind of circling back to the earlier discussion, the idea is to get at the requirement that we essentially would have to maintain two separate voter registration databases, essentially, one for state and local, one for federal elections, is basically what I think is the argument and what this may require. I don't think calling it a two-tier registration system is quite precise enough to really get at that point, because that
It's
doesn't
really way too confusing.
get at like what it does to me. And I'm not sure if I'm a voter looking at this, I don't know if I would understand two-tier.
I agree. The wording on this one is, you have to be very careful because this could mislead a voter quickly. And you're not really decoupling the federal and
And I'll just point out something will have to be cut then. So if we want to add it in, that's fine, but then I need to know what does the board want to remove? And then I can maybe come up with some.
Correct, that here in section 4, it specifically requires the Secretary of State to distinguish between any separate list of individuals eligible to vote in state and local elections or in federal elections. So there is an explicit recognition.
I would phrase it more of that way. Instead of calling it two tiers, like phrase it more with what is in there, because I think that's a little
Right.
clearer. Yeah, and if that's something we want, what I would recommend is what is okay to, like, what is the thing that we want to remove? And then I can try to wordsmith and provide something based on what we're wanting to remove.
Instead of the word remove, how about compress?
That's fine too, right? But I just mean, we're at 100 words right now, so something's got to give because I can't add, right? So that's what I mean, like what's gonna give?
you get rid of the words by showing. It's implied that if you're gonna present a birth certificate or something. Fifth line down, citizenship by showing birth certificate, passport, and or other documents. You could simply require proof of citizenship.
You could be using, it's one word. Via. It's one word.
You could just say with instead of by showing.
With. I think the idea, the reason I use showing was to represent that the voter has to take some action. So I would suggest probably like using or something like that to kind of keep a line with that. The voter has to do something. Still saves one word, but.
So I think if you said, well, I think this documenting citizenship and voter rolls is pretty important. I think that that's 5 words. If you said, for state and local elections require Secretary of State verify citizenship of registered voters. That
Good chunk of words and other words on it.
You tell me.
I would put it, I would put it in front of require for state and local elections.
Well, they're calling it out the receiver vote because right now for an absentee ballot, you couldn't request it. You're gonna have to follow through and it's just request it.
Yeah, I understand that. I'm just saying like the process of to vote absentee. Everything, you know, kind of all encompassing.
Yes, that's fine.
Yeah, I know we spent a lot of time on it last time, but that would, if we changed that and say going to.
Let's get rid of 3 words.
Get rid of 3 words. For that, I guess it's more.
What Paul said is if we take out the to receive or vote an absentee ballot, simply say, simply make it to vote absentee.
I know we worked on that a lot last time, but if you really wanted to save some words, I mean, that entire process, most people who vote absentee are aware of at least what that process is. You could say to vote absentee. And that would save you quite a few words. I think most people understand what that process is if you're doing it.
How many words can you,
Right.
to express the new context, to express the dual vote, the dual lists? How many words do you need?
Why don't, if you wouldn't mind, if we take a recess and maybe I hear that you want to figure out this, give me some time and we can.
We will.
Wordsmith,
It's 5
remove.
words, so we'll give you 5 minutes.
Oh. I feel like my time is getting shorter and shorter. This is going on.
We're going to take a 10-minute recess. Meeting stands. Better way to put it, yeah. Any other way you put it is either we're gonna have to go with Mr. Ziegler's long explanation, or you're gonna have to.
But it's not.
That's
Happening unless. Right.
That's the tricky part.
But it makes more sense than two tier.
Oh, no. I don't understand.
Right. It's two.
Well, you know what, that makes it so confusing for so many.
No.
Oh.
I mean, I can see people interpreting two-tier, yeah.
Right.
I did think about that, but if we just hyphenated everything and then slashed everything, you could have a very long.
Because the citizenship modifies the voters, it doesn't.
Yes, exactly, exactly. I did think about that.
Okay, I was just trying to. I'm sorry. Oh, yeah, that kind of. So.
No.
Yes. Um. No, I mean, I'll take it.
Yes. but we have to make it.
Stupid computer.
Words.
Oh.
I say I got it. That. I'm not, that's just what was provided. I'm not guaranteeing.
Yeah. Great minds coming together. That's my photo.
I know.
25. We have what I hope is a final draft here. Would you like to read it?
Of course. I'll read it first and then kind of say what I changed and why. So it's Constitutional Amendment 2, require Secretary of State verify citizenship of all registered voters, document citizenship, remove non-citizens using governmental records, and maintain separate voter rolls for federal and state/local elections. Prohibit counting ballots from voters with unverified citizenship unless voters show documents to Secretary within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternative for voters without photo ID. Require photo ID or driver's license or partial social security number to vote absentee. Require state-funded hardship program for obtaining required documents. Subject violations to $1,000 fine and/or up to 5 years imprisonment, and that is 99 words. So I added the documentation in, I removed the document citizenship piece that we had in there. Previously, we had document citizenship in voter rolls. I moved that up and coupled it. So the first clause is all of the things that is required of the Secretary of State. So it's required the Secretary to verify citizenship, document citizenship, remove non-citizens using governmental records, and maintain the 2 separate voter rolls for the respective elections. And then everything else is more of what's on the voter. Or like the local clerk, for example, with prohibiting counting of ballots, like those pieces. So I was able to save some words there just by moving those up and kind of combining that first clause into making that all secretary focused, and then removing the other stuff by putting it up there. So that got us to 99 words.
Comments? Sure. You would.
So I guess my first question may be a rhetorical one. I want to make sure that we're all working from the same language in the petition. What is the basis in the petition for this new language? What provision or section are we talking about that requires adding this new language about 2 voter rolls?
I would say the basis is that that if this passes,
Mhm.
it will require different verification procedure. It would require different eligibility requirements for state and federal elections.
You've
If,
accepted it you have it in paragraph 4 here.
So unless federal, I think as we've clarified, unless federal law changes,
Yep.
we're going to have 2 separate systems.
So if it's paragraph 4 of the petition that's sort of animating this, that's a report that the Secretary of State is sending to members of the legislature. There's no requirement that you maintain 2 separate voter rolls. So it is inaccurate to say that you have to have 2 separate voter rolls for state and local elections and federal elections. And I understand the sort of the potential inconsistency that there might be in terms of registering. I think there's an easier way to get about that change. If we go back to the previous version of this, the clause that begins with for new registrations, because that's what we're talking about here, it's for new registrations in state and local elections, you have to identify or present documents of citizenship, whereas that might not be the case in federal elections. Again, that's a hypothetical. We don't think that we should be even contemplating hypotheticals, but if we are going to add language, you can just add the phrase for new registrations in state and local elections or state/local elections. I think that satisfies this.
I don't think it does, because it's going to be applicable to all voters.
But only in state and local elections. And that's the point that the
Right,
gentleman
so
that was just
it's
up here.
applicable to all voters in state and federal elections, and that's why in state and local elections, and that's why you have to have 2 lists.
No, well, you don't have to have 2 lists, but it's only for new registrations in state and local elections that you require proof of citizenship by showing birth certificate, passport, and other documents. That's true and accurate.
No, except it's not, because in the new registrants are, with regard to going forward, the new registrants are in no different position than the existing registrants. Because in state and local elections, they're all going to have verified citizenship.
No, they're
Okay.
already registered. And so the question then will become, is the Secretary of State verifying whether or not they are a citizen using documents and government records?
Secretary of State doesn't verify, then they can't vote in.
If they
in any-
verified that,
In state and local elections.
if they verify that they are not a U.S. citizen, then yes, they are removed from the voter roll. But unless and until then, they continue to vote, subject to the provisional ballot that we've discussed earlier. But what we're getting at here is a tweak to the registration process that is a potential inconsistency with federal law. Again, that's potential. We're talking about
It's not
potentialities.
potential, it's accurate. Right now, if this passes, that's what we're going to have, is inconsistent state and federal law, which will require two lists.
But just in the registration process, in
No.
what you need yes, in what you need to present in order to register to vote. In Michigan, for state and local elections, it will be you need to provide proof of citizenship documents. Under federal law, assuming that there is no change in federal law, it would be, you can fill out your affidavit of citizenship. So that's the potential inconsistency, but it's only for those who are registering to vote after December 18th, 2026.
Or who are not verified by the Secretary of State.
But those would be people who are already registered to vote. And then when they're verifying, they're verifying whether or not you are a U.S. citizen using documents that the Secretary has access to that are not documents that the individual
If they're not
voter.
verified, it doesn't mean that they're not citizens. It just means that they're not verified yet by the Secretary of State.
Correct. And the only way that they'd be removed from the voter rolls is if they've determined they're not a U.S. citizen.
But they may be unable to vote a regular ballot if they're not verified, even if they are citizens.
Through the provisional ballot process, yes, but that's not, has nothing to do with the potential inconsistency in the registration process, which was the whole point of making this last tweak.
I can maybe help with this a little bit. So I think there's a couple of things. So if we're talking about just what is the basis for the two separate lists, subsection 3 in about 8 lines down specifically says removals can be made from the list of individuals eligible to vote in state or local elections at any time after the requirements of this subsection are satisfied. And then continuing on, removals arising from the citizenship verification program can be made from the list of individuals eligible to vote in federal elections at any time. So that does suggest to me 2 separate lists as well, with the insertion of the word "the" before it. It's a definite article. And then having it broken out to say the list to eligible to vote in state or local versus the list eligible to vote in federal elections, coupling that with the subsection 4 language that just says distinguishing between any separate list of individuals eligible to vote in state and local elections or in federal elections. All reading those 2 to me does suggest that there is this requirement on us, on the Secretary of State, to have and maintain a state and local registration list and a federal registration list.
Well, what subsection 3 is referring to is this 90-day deadline that can or cannot be excused through federal law. That's the only difference between that and being able to be removed from eligibility to vote in state and local elections.
Right, but I think the 90-day deadline is different from what this is doing. The 90-day deadline is under federal law as well that says you can't remove from a federal election. And even looking at that, the specific says, like that language says, eligible to vote in federal elections at any time more than 90 days before a general or primary federal election. So again, I don't take a position on whether or not the board wants to keep this in or we want to take it out. I don't take a position on that. I am simply just trying to provide guidance on, as I read the petition as it's presented, that is the language that I would point to support why I drafted the summary I did.
I think what you've done on the summary, exception to how you're presenting it, sir, but I think what's been done on the summary is a fair way to put it in front of Michigan voters who you're asking to sign this petition. I think to play to what you're saying is the road that you want to go down is a much more complicated road. So we feel like we have to put it into this 100-word summary. But I think that the way that you're describing it is, we're not going to weasel word it again.
Just to be clear, my proposal was adding 3 words to the summary, but I understand
I
that
felt
the
your
board's.
words made it more confusing to me to understand.
Well,
I think you've got to, yes, sir. You may certainly have a second.
My name is Paul Jacob.
Could you spell that?
Jacob. I'm chairman of Americans for Citizen Voting. I think there's, maybe we're not all on the same page. There is a law that was passed in Arizona that requires people to show proof of citizenship when they register. That law was litigated, and there was an agreement made between Arizona and the federal government over what to do. To suggest that if this law were litigated, the same result would happen is not only not certain, I think it's wide open. But there's another issue here, which is, I think there's a supposition that this is caused by the Secretary of State looking through all these voters and checking their citizenship. That's not what Arizona has done. Arizona requires that proof when you register. Our proposal requires that. So does the proposal you approved a couple of weeks ago with none of this discussion. And it seems to me that if it's true that you needed to put this in now, you certainly needed to put it in before. But the truth is, this is speculative. We don't know what a court will do. We don't know what the Michigan Secretary of State or Attorney General will agree to, or what the federal government will say they want. The federal government may say, we're fine with it. It will depend on who's in charge of the DOJ at the time. So the level of probability here is a lot more complicated than I think has been recognized.
I would say we're not Arizona, so that's, I understand why you're mentioning that, but this is Michigan. Okay, so we're talking about Michigan today, and I agree with you that the probabilities and all of the arguments and all the potentials and the futures and the maybes is what we've mentioned before. This will end up as something that is litigated. For the people who you're going to present this petition to, the way that they have added in the dual roles or the dual lists, I think completely fairly reflects what we're talking about here. I don't, the voters are not going to take this to a probability level, and they're not going to worry about somebody else.
This language says that we are requiring the Secretary of State to maintain 2 separate voter rolls. And that isn't accurate. But the other part, I'm not bringing Arizona in on a whim. The certainty that this is going to require 2 voting rolls is all based on litigation out of an Arizona law. And it's not litigation where a court came down and said, this is what you have to do. It's litigation where the state of Arizona and the DOJ reached an agreement. So that's not some sort of precedent that is just a slam dunk. So the reality about whether there'll have to be 2 voting rolls, I think that's a very open question. And what we're saying in this proposal is, if that happens, then of course they have to look at both of those. This is looking ahead and just making sure all the bases are covered, but nothing in this proposal could be said to require the Secretary of State to maintain 2 separate databases. And if that were the case, of course, the petition that you approved that made no mention of any of this does the exact same thing.
The petition that we approved last time did not affect already registered voters. We were worried about that. We understood that it did not affect registered voters. This petition affects all registered voters. And that is why it is totally distinguishable and why we spent so much time distinguishing it. Now, what you say about Arizona, and I have not read the case, but you say that in Arizona, they just required new registrants to provide proof of citizenship. So does your proposal, but it also imposes this other really draconian requirement that the Secretary of State verify everybody's citizenship. And then where that doesn't happen, then the people have to vote provisional ballots. So that's a huge and, it requires everything to be different.
Well,
including-
I recognize some people are going to see that as draconian. I see it as the best thing since sliced bread. But it isn't, all the predication of, oh, we're going to have two lists has nothing to do with the secretary. Nothing stops the Secretary of State from checking voter rolls and removing non-citizens. They could do it now if they had the will to do it. We're requiring them to do it. But that has nothing to do with two separate voter rolls. That's not where the controversy was. The controversy was on registering to vote. And so I'm just pointing out that it is the same in that regard. It's precisely the same as the previous petition.
If this were put into place today, if we could make a magic wand and all the people in Michigan signed it and they had the election tonight, tomorrow morning, would the Secretary of State be required to have two lists?
No, no.
I'm hearing two different answers to that, though.
No.
I'd be curious.
I don't think there's any question. Someone would have to go to court to require that. Even if the courts were to be of that mind, there's nothing in this requirement. If this passes and it's not litigated, or it is litigated and the other side doesn't win, there's nothing that requires two voter
Well, if you
rolls.
change the, I mean, practically speaking, if the election were held tomorrow and this were in place, two lists would still result.
I don't think so. I mean, they could. I understand how it could, and we don't have a crystal ball. We don't know what agreement might be made between the parties. We don't know what court, what judge, whether it goes all the way to the Supreme Court. So we don't know. It is a possibility. I certainly wouldn't deny that. But of course, that same possibility is there anytime you require someone to show proof of citizenship when they register to vote. It has nothing to do with the Secretary of State checking. We love the Secretary of State checking, but that has nothing to do with this, with having to have a separate federal only voter roll.
Can I ask, in section 4, it actually says, so not later, I won't read the whole thing, but not later than January 31st of each year, the Secretary of State shall submit a report to each member of the legislature summarizing. And then it goes on to say, okay, and the number of individuals whose citizenship was verified under the citizenship verification program, distinguishing between any separate lists of individuals from the state qualified voter file, including any separate lists for individuals eligible to vote in state and eligible to vote in state and local elections or federal elections. I mean, this separate list is coming from your document. This isn't anything that, I know you're trying to distinguish what we did last month, but this is, these words are coming directly from this document that we've been reading.
But let's look at those words. Any list. If there is any other list, if in the future Michigan is forced to have two lists or agrees to do it in some court case, which is again, all speculative, we don't know what will happen, then this covers it because it says any. It doesn't say in the future, when you have a separate federal list, check that list as well as this list. It leaves it open because it recognizes, look, law is churning and changing every day. And we want that in the future to not allow someone to say, oh, I don't have to check this one list over here. So it says only, it says any for a reason, because any list that there could be, that's a federal only list, any list that's a state and local list. It does not say you have to have a separate state and local from federal list. And if you read the 100-word summary, it says we required the Secretary of State to maintain separate lists. She'll be forced to maintain separate lists no matter what the federal government says, according to the wording of that summary. And I think it's inaccurate.
She will be required to have a separate list. As you said with Arizona, you would have a separate list of people who register with proof of citizenship or without proof of citizenship, because you're not required under federal law to register with proof of citizenship. So you're going to start with that, but you're going to have that. And you're going to have it to a greater extent here than in Arizona, because it's applicable, excuse me, to new registrants and to existing voters where the Secretary of State has not completed the verification process.
It won't have anything to do with the Secretary of State's checking. That's allowed in every state. We only mandate it, but that doesn't trigger it. It's the having to have that proof, because the federal form that they've established, states don't have to use it exactly, but they've, in this court case, they agreed you have to allow people to vote with just checking that box, taking them for their word that they're citizens. And then in that court case, they agreed to keep a separate list, because that's the only way they could keep the verification for the state and local.
That's the point.
This body is assuming the litigation is going to go the same way if this is passed and there's litigation. We don't know there'll be litigation. We don't know how the litigation will end up. And it seems to me to suggest that this measure is requiring the Secretary of State to maintain a second list is just factually not accurate. Now, there may be a different way to say it. I still think it's all speculative. And it really doesn't have to do with the other petition, but of course, this particular aspect is one of the things that's exactly the same with the other petition. That's the only reason I bring it up. But it has to do with the voter registration form. It doesn't have to do with checking citizens as a whole, and in checking the entire voter list.
You have 99 words, so you've got one extra word. You could put the word potentially, or you could put the word in front of the word maintain.
I have a question for our attorneys or Adam, whomever. I know that this is, I certainly understand what you're saying. I guess my question is, as you read this, you know, you would have to be the ones that implement this. As you think about the implementation of this, do you believe that as you implement, that you would need to either have some sort of separate voter roll, or maybe just, you know, confirming eligibility status for a state, federal, local election? I don't mean to put you on the spot. I know that that's a lot. But I'm curious as to actual, you know, the implementation of this. Do you feel that that would be a requirement as you implement what would be required of the Secretary of State's office?
As I'm reading it, just as this is now, I do think that there would have to be some sort of distinction. I don't know exactly how we would do that, like the specifics, because that just has a ton of variables with just programming, et cetera. But as I read just the plain text of this, I'm looking at the list of individuals eligible to vote in state or local elections. I'm looking at words like that. The word "the" is really striking to me. And I'm seeing the separation in the plain text of the constitutional amendment that really has this separate dichotomy between state and local elections and the requirements for removing folks from that list versus requirements to remove folks from the list of individuals eligible to vote in federal elections. So that tells me that the amendment does contemplate some sort of separation between the two. Again, kind of going down to 4, kind of saying the same thing. If we have to report to the legislature, quote, distinguishing between any separate lists of individuals eligible to vote in state and local elections or in federal elections, that again has a separation to me to mean that there has to be something. I mean, if we weren't required to separate it, why would we be required to report to the legislature on it? Coupling that with that other language. This language was not present in the prior one. There was no separate
No, there was
list.
not.
There was no separation like that language is present here. So that to me, I mean, words matter, right? Like, so that's in my mind why I am inclined to say there has to be some sort of separation. I don't, again, know what, but
And I guess I agree with you. And as I'm listening to this, maintaining separate voter rolls, I think that's a pretty strong statement because that's not necessarily what you would even necessarily, you could probably check eligibility status in the same voter roll, right? Potentially.
I don't know one
Yeah.
way or the other sitting here, honestly. I think that would really just depend on a variety of factors.
If you have different eligibility requirements for state and local elections and federal, there is going to be the requirement that you're distinguishing between those two groups of eligible voters. And that's going to be a distinction that is going to have to be made in the polling place.
Could I speak to that?
Yes, please.
There is there are no, you're not allowed to vote in federal elections if you're a non-citizen. Now, there's certain mandates that you not check in Arizona where they had this specific litigation. But you're not allowed to be a non-citizen on federal rolls. That's already, so there's not a different requirement. There's not and in fact, if you look at the US Constitution, Article 1, Section 2, it says that the requirements to vote in all federal elections are the same as to vote in for the largest chamber of your legislature. So it's not a matter of there being different requirements. The only difference is that this one bit of litigation said it's good enough for someone to just check the box. So even in Arizona, they could go check everybody's, and if they found you to be a non-citizen, they could take you off the rolls. It's not a difference in requirement or what you have to be or who you have to be. And that's set at the state level. It's not necessarily set at the federal level.
But you have to distinguish between people who've satisfied two different requirements. I agree with you that federal law says you have to be a citizen to vote. Michigan law says you have to be a citizen to vote. So this whole thing is a useless exercise. But apart from that, just to be frank about this is an extraordinary amount of effort devoted to finding the 2 or 3 people who may have mistakenly registered to vote. But you're having 2 different eligibility standards. And so if you have 2 standards, you got to have a way to break them down. You're saying, but don't have to have 2 different roles. Maybe you could do.
What I'm saying is there's not 2 separate eligibilities. There's no disagreement that if Michigan says, that you can't vote as a non-citizen, you can't vote in federal elections either. It's the registration process that's at issue. And that's why the bigger check of everybody who's already on the rolls doesn't implicate anything that went on in Arizona in this one particular case, which is being treated as certain to determine every other case.
Verification.
I understand your arguments. Adam, I also understand that practically speaking today, the interpretation of this would require you or the Secretary of State to maintain separate lists. I don't know if there's a different word you want to use beside maintain. Mr. Cordes has raised the question of, do we call them voter rolls? I don't know what else you would call them.
So the only reason I used voter rolls was because I think that that's a little bit more common speak for voters. I'm not wed to that. I mean, one option I think you could get at if you wanted is to say maintain separate lists. You could use the exact text from the constitutional amendment petition itself.
Word rolls with the word lists.
You could do that, voter lists. I mean, I think there's other things you could look at as well, but I mean, if the concern is just what should we do with voter rolls? The only reason I put that is just because I thought it was a little bit more specific than the word list, just as to what we're being. What is this getting at? So, and it tied with, we have to track the citizenship status and everything in the what we call the qualified voter file, but I don't think the average voter is gonna know what the qualified voter file is.
So if we use.
Could
the
you
word-
just, oh, sorry.
If we use the word lists, which, as you just pointed out, is the same word that you were using in your petition. We use the word lists instead of the word rolls. Is that still conveys to the voter or to,
Could you just say maintaining eligibility for federal and state local elections? I mean, that's really what, I mean, you're doing that anyway, right? Like you are, no, whether this does happen or doesn't happen, really, it's just a matter of eligibility, right? So if you're maintaining someone's eligibility and if there's a change in federal law or state, whatever it is, then eligibility will change. So really what we're just talking about is eligibility, how you track it or what separate list you have. I don't know how, how you guys will end up doing it, but really it's a matter of maintaining someone's eligibility status, right?
I actually like that.
Separate eligibility list.
What I would suggest is, and something like, and getting rid of maintain separate voter rolls for, and then replace it with something like, track eligibility.
Yeah.
Or federal and state / local.
Yeah, I think that's cleaner and less,
track and
Track
track
eligibility
eligibility
For
for,
federal and state / local elections. Or maintain whatever.
maintain eligibility, track eligibility. I don't think it.
Eligibility.
No, either maintain.
gotta either be maintained or.
Pick.
I do think that might be a little bit more precise as well.
Yeah.
For federal and state / local elections.
Adam, would you read that clean sentence back?
Sure. Constitutional amendment to require Secretary of State verify citizenship of all registered voters, document citizenship, remove non-citizens using governmental records, and track eligibility for federal and state / local elections.
Yes.
Yes. They're always tracking eligibility for federal and state and local elections. So the point is that it could be different. Right?
I think that's my argument for why that would suffice, because say for federal and state / local election and local elections in the event that it was necessary, we've got it says track eligibility for federal and state / local elections, where it kind of signifies that there may at one point be a difference between federal and state / local.
Yeah, you could use the word separate.
But again, there's no difference in the eligibility. From a legal
There is,
standpoint.
so.
There's a difference in the way it's checked or the way it's established, but there's no difference in the eligibility.
You could do track separate eligibility requirements for federal and state local elections, and that would still be 99 words.
You know, I might just offer, I think using the language from it, because I would argue that this is only speculative if there's a separate list. You guys see it differently. Obviously, people can see things differently, but using the language that's in there makes a lot of sense. That's why eligibility is a good word, because eligible is in there. Anytime you say it's a separate list, then you are saying this petition will require you to keep a separate list. And I don't think you can find anything in this petition that requires you to keep a separate list.
About the voter who registers to vote pursuant to the NVRA, doesn't provide proof of citizenship and doesn't provide it to the Secretary of State. That voter can vote in the federal election, but not in the state. Isn't that true?
No, that voter will not be able to vote in the state election. That voter will
And
be,
if that voter can't vote in the state election, but can vote in the fed,
that voter can't vote in any election until they establish that they're a citizen, because it's been, from checking, they can't find that they're a citizen, or they have some suspicion or evidence that they're
no,
not.
but this is
Covers
a
down.
new registrant, because that's what you're talking about with regard to Arizona. The new registrant registers in accordance with the NVRA. That voter says, yes, I am a citizen, but is not required to provide documentary proof. If that voter does not provide the documentary proof to the state, can't vote in the state, but can vote in the fed.
They won't be able to vote in the federal election because they're not registered to vote in the federal election. The Secretary of State will keep one voter roll, I think, and obviously they're free to keep as many as they want, but with one voter roll, they will check. And if that person who registered without showing proof of citizenship is found that, oh, we can't verify their citizenship, then they will be stopped from voting. And not only in state elections, but in federal elections.
But what you're saying is that you don't even need the SAFE Act. You're saying, aren't you? Because you're saying.
Well, I'm not here to argue for or against the SAVE
Okay,
Act.
but you're saying that the proposal recognizes that there could be a different federal standard, that federal law may change. But you're saying it doesn't matter if federal law changes, that right now, if the person doesn't verify the citizenship when they register in a federal election, they can't vote in this election. You know, maybe this is just going.
If different point, just for the election director. I think in the semantics of lists and roles and whatever, and I'm just thinking that in terms of, you have a computer record and it says Joe Jones, S state and local, F federal. I mean, and I know you don't know how it would be implemented. I'm just saying, to me, that isn't a separate role and it isn't separate list. It would be one list of names with one or two designations.
That's why I think that the best language is what we've suggested with track separate eligibility requirements, because that kind of gets at the point that you have to have two specific separations.
Let's do this.
So,
Let's put
yeah.
that together
Could we-
in the writing and
Yes.
let's.
Could you
let's
use the
print
word
it, and then
maintain?
Let's move it to a vote.
Yeah.
We've got other business yet to do
Yeah.
this afternoon.
Could you use the word maintain separate list, or maintain eligibility, maintain instead of track? Does that? Track, make it sound like
Well,
you're
we
following
just went
somebody.
through the,
I would keep with track because
Very
it's-
good.
yeah.
You've had a long day. I'm not gonna make it longer.
No, that's fine. It is not, I just think track is more accurate. So that's my main rationale.
Thank you very much.
we're just going to stand in recess for 5 minutes while we get this done.
It's my bathroom.
To come.
That one, okay.
Are you gonna let me? You want me to sort of? Whatever you wish. After the business. After the vote, right? Okay, so I just wanted to point out some recent testimony in the elections.
Jim.
Richard, I'll see you later. Bye. It's good. No, you're right. I'll talk to you guys later. No, it is. Thank
We are reconvened. I would ask that one final reading of, ask that Adam would do one final reading of the 100-word summary.
Sure. Sure. Okay, so Constitutional Amendment 2 requires Secretary of State verify citizenship of all registered voters, document citizenship, remove non-citizens using governmental records, and track separate eligibility requirements for federal and state/local elections. Prohibit counting ballots from voters with unverified citizenship unless voters show documents to Secretary within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternative for voters without photo ID. Require photo ID or driver's license or partial social security number to vote absentee. require state-funded hardship program for obtaining required documents, subject violations to $1,000 fine and/or up to 5 years imprisonment. And it's 99 words. I don't think I need to get into the why. I think that's been covered pretty good.
Do we have a motion? Oh, you want to speak?
No. I'm
gonna
move it.
Oh, you are? Oh, that's great news.
Move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Americans for Citizen Voting Michigan as drafted by the Deputy Director of Elections and presented by the Deputy Director on May 16, 2025.
Second. All in favor?
Aye.
Motion passes. Moving on. Item number 4 on the agenda is the consideration of the form of the constitutional amendment submitted by Americans for Citizen Voting, Michigan. This is actually on the form of the petition. Each member's been given a copy. This has been looked at by elections.
Yes. All of that's correct. This has been posted on our website as well. So as normal, what we do with the form requirements, when staff is reviewing the petition form itself, we are just looking at the size of the document, et cetera. Our review does not extend to the specific text of the petition itself, the specific language in the proposal. The only thing we're looking at on the back side of the proposal itself is it the right size? And are the elements that have to be there present? So staff has reviewed this. It does comply with the requirements.
Meets your requirements, and I think we have a request from,
Yes, just a point of clarification or additional request in communicating with the staff about the form of the approval form. We inquired whether we could put sequential numbering on the ballots to ensure that we can track them. And we were told that we're not allowed to do that, but we can use a QR code or a barcode as the board has approved in the past. And so with our request to approve the form, we'd like that to be to confirm from the board that it will not invalidate the approval of the proof of the form if we add the barcode or the QR code, and that it will not be considered a disqualifying factor for the petition form during the approval and sample process.
Can I respond? So to be clear, you can use a sequential number. The question was asked was about the specific location of it. Sequential numbers are fine. We typically do not require they provide that with a copy of us for the form stage, because that changes, right? It changes with every single petition. And it's not a mandatory element under election law. So that's typically where the board has not required that. So if circulator groups want to use a QR code, a track number, what we always ask is that it not be in the upper right-hand side of the petition, because that's where we put our stamp. And if it goes there, it causes us a lot of problems with processing. So we always recommend that it goes somewhere along the bottom. A barcode would work, like a printed barcode we've seen. The thing that we always caution against is to use a sticker of some sort, because if you put a sticker on and it covers up a mandatory element, anything on this page, that entire sheet is invalid. But relevant to this, we don't typically require that tracking element at the form stage, just because, like I said, it changes. We view it as more of like a function of the group and not a role for us.
so with all of the expensive legal horsepower in this room right now, I'm going to give you the most valuable piece of free advice. Will you, if you're going to put an identifier on there, will you make up a copy exactly how you plan to do it? And will you make sure that Adam and the folks at elections get it before you go to press and print out 100,000 or 200, right?
Yes, we will.
I will also emphasize, sorry, and you, please, I didn't mean to
You
interrupt.
want him to do that before we approve the form?
No, because we don't need it to approve the form.
We just
can
wanted
approve it.
assurance that if we moved ahead in light of the guidance that we received from staff, that it wouldn't be a disqualifying factor if we added that after the approval process.
He's just verifying that he could put the identifier on here later. It doesn't need to be on here for us to approve the form. And Adam, you're confirming that. And I'm
Articulate
simply
board
suggesting
practice.
before you do
Yes.
it, just make sure you bring in a copy of the real deal.
Yeah, the next step for here, just as a reminder and just for anybody that's not aware, the next step is the board has obviously approved 100 words. That has to be replaced. Section 483A of election law requires an additional 15 copies of the as circulated version to be filed with our office. If that does not happen, any signature that is gathered is automatically invalidated. So we have to have an as circulated version prior to any group being allowed to start circulating. It's usually at that point, that's when we get the like barcode or something like that on it.
You have an enormous
Understood.
resource with these folks and they will help you make sure it's in exactly the right spot.
Oh, thank you. We appreciate it.
Before we do a motion, I think Mr. Ziegler asked if he could speak for a moment. And you have to keep it really short for me, okay?
Very brief, very brief. So this board obviously knows it usually grants conditional approval subject to that 100 words being swapped out. And there is some examples where they do not grant conditional approval, and that is when the 100 words needs to be swapped out and when there are typos in the text of the amendment. Here, Article 2, Section 1, Clause 4 has the word WOHSE, which of course is not a word, it's a typo. Article 2, Section 1, Clause 4, fourth line down on the right-hand side.
Oh, yeah, WOHSE.
You know, you did refuse to approve the form of an amendment, of a petition when member Dawn
Brought up.
noticed
typos.
that there were typos.
Did we refuse to approve it or did they withdraw it? They withdrew it and they presented it at the next meeting, I believe. Is that correct?
Remember?
I've-
Whether, I know,
I have a
That-
transcript in front of me, if that would be helpful.
I'm sorry,
I have the transcript in front of me. It was the September 23rd, 2021 meeting with Secure My Vote. And board members Matuzik and Bradshaw both said, I'm going to vote no. This is not the 100 words that we usually do. These are 100 words. These are typos. This is an error with the printer's affidavit. Fix it all and bring it back.
okay, so none of us were on the board at that time, but I do recall member Dawn with a, discerning eye found some typos in a petition. And either they withdrew it, as you point out.
They withdrew
You
it and
think
brought
they
it back.
withdrew it as opposed to are rejecting it?
Well, and that brings up another point here. I'm just going to ask this for clarification because I asked it last time when we had this come up with Tony's. The wording as it appears on this petition, if this is gathered signatures and it's blessed, is the exact word, the wording can't be changed. This would be the exact wording in the Constitution then, correct?
Correct. At this point, I mean, you can change it, but you have to start the process over.
No, I
right?
get it.
But yeah,
The
like,
point being is if this were approved and we're setting it up so that this spelling would then carry through
potentially, yeah.
potentially.
I don't know the exact of how that piece of it works when it goes like to, I don't even, LSB maybe that does it, but
And this is why two members of the board, so I believe it's correct that the petition was withdrawn, so there was no formal vote of no. But two members of the board did express, I will vote no. This is on page 88, lines 8 to 18 of the transcript. So I think there is sort of a soft precedent of the board that where there are typos within the text of the proposed amendment, the board does not approve or conditionally approve until they see a clean copy, which is the words that board member Matuzik
Our
repeatedly uses.
conditional approval in the past was conditioned only upon substituting the approved 100-word summary and not conditioned upon correcting typographical errors.
That's right, not to any change in the text of the amendment.
I want to just jump in and answer a question that was asked. So at the September 23rd meeting, I'm just looking at the meeting minutes right now. obviously he's got the transcript as well. What the minutes say is there was no motion made on it, so the board did not formally adopt or reject it. It said the sponsors will submit a revised petition to be considered. So I think that they did, based on that, I think that they withdrew or said, we'll withdraw this item, to be clear, just the form piece, and then come back.
Am I
For what it's
under the assumption that if we proceed forward with a motion, you're not? Let me rephrase that. I'm going to ask the petitioner first. Do you want the ability to withdraw this petition and correct it and bring it back in June?
That's my answer is that is a question, which is, we would ask that it be conditional on us substituting not just the summary, but also that word.
The summary we have already moved and approved and gone through. The summary, if I'm not misspeaking your process here, the summary is already done. If you withdraw the body of the form and you correct it and reschedule to come back and put it on next time's agenda, that would be a separate vote.
My response to that would be, if we're able to make the approval conditional on us substituting one portion of the petition, we'd ask that you make this, by the same logic, allow us to replace that one word and replace it with the correctly typed word.
There's another typo. But so I would suggest it's not just one word. I don't know if your argument's going to be the same, but well, I'm not trying to withhold it. I didn't mark it on this one that I have, so I saw it a couple days ago. I can email you if you want, but.
Okay, and I think what we did recognize when Member Dawn brought this to our attention was that it was not our job to correct or conditionally approve with regard to typographical errors. Our condition would only be with regard to substitution of the approved summary. So
I can't speak for my fellow board members, but rather than do this on a conditional basis, I really would like us as a board to see the revised copy before we vote. Is that fair?
If the policy is making our conditional on the replacement of summary language, then our position would be, would like to withdraw the petition and bring that back. Item number 4.
Your summary's been approved. No one's going to touch that. This has to be corrected though, or otherwise it will go to, if you want us to vote on it now, I can pretty much guarantee what'll happen. So you will withdraw this and you'll correct it and then bring it back. Okay. All
I
right.
just want to make clear, just for the record, we're talking about withdrawing as for approval as to form only, correct?
Yeah, correct.
I see
Yeah.
nods, and so I'm going to say yes to that. Okay,
Summary stays in place.
thank you.
Moving along,
Oh, wow.
item number 5. Thank you, Mr. Ziegler. Item number 5, we have consideration of the proposed de minimis modification to voting system Dominion Democracy Suite 5.20 hyphen ECO number 101025. And let me pull it open. Will you summarize what you're looking for it too, aren't you?
Yes, I am just also trying to get myself organized among the paper that I have as well. That is this one. Okay, thank you. So this is a proposed de minimis change to the Dominion system. Essentially, it would replace a computer monitor for the EMS system that's at the county level. The current monitor, in layman's terms, is just not being made anymore, so we need to update it to have a new one. The current monitor has reached its end of life state. I was looking for confirmation to make sure I'm using the right words. So this de minimis change, again, it's gone through the EAC, it's gone through a voting system test laboratory already. So this de minimis change is essentially just to replace that the Dell P2425H monitor with replace the P2422H monitor with the P2425H monitor.
Any questions? Need a motion?
I move that the Board of State Canvassers approves the use of the Dell P2425H monitor as a display device for server and client workstations due to the Dell P2422H monitor becoming commercially unavailable for the Democracy Suite 5.20 voting system in the state of Michigan.
I have a second.
Second.
All in favor?
Aye.
Aye.
Aye. Item number 6, consideration of the, I'm sure I'm on the right line here, hold on. Consideration of the proposed de minimis modification to voting system Dominion Democracy Suite 5.20-ECO bound 101046 and ECO 101047.
So this is also a de minimis change. This is just essentially two different components. So we put it together. But again with Dominion, de minimis change that's gone through the EAC as well as Pro V&V Vistal Test Lab. The component, same situation. We're at end of life with the current. Essentially, it's the Ethernet network switch which connects to the EMS system, and to swap it out to have one again that we can have versus the old one, which is now at an end of life again. So the two that we're looking to replace would be a 24-port Ethernet switch, and we can kind of see in the memo kind of the reasons why, as well as a 8-port Ethernet switch for both components. So, and again, both are just the current version is at end of life.
I actually looked those up for you online and ran the back tech on those. So yes, you are, and there's even a security improvement in the new ones.
Yes.
Do I have a motion?
Yeah, I move that the Board of State Canvassers approves the use of Cisco 24-port Ethernet switch C1300-24T-4G due to the Cisco CBS 350-24T-4G Ethernet switch becoming commercially unavailable for the Democracy Suite 5.20 voting system in the state of Michigan.
In favor? Oops.
Support.
All in favor?
Aye.
Aye. Number 7, consideration of the proposed de minimis
I need a second one.
Second
Yep, there's a second motion as well before we move on to number 7.
Oh, I'm sorry.
It's
There were two.
separated.
Yes.
Forgive me.
Yeah.
Oh, what, they were together. My
They are
mistake, forgive me.
together.
I move that the Board of State Canvassers approve the use of Cisco 8-port Ethernet switch C1300-8T-E-2G due to the Cisco CBS 350-8T-E-2G Ethernet switch becoming commercially unavailable for the Democracy Suite 5.20 voting system in the state of Michigan.
Support.
All in favor?
Aye.
7, consideration of the proposed de minimis modification to voting system Hart Intercivic, Inc. Verity Voting 2.7, ECO 01679.
So this is another de minimis, similar to the ones with Dominion. It's a different piece of equipment. So this is essentially the rollers on the tabulator. On all of the Hart system tabulators they have reached end of life and are now also commercially unavailable. What's a little bit different with this one is because it is a new, it's a new roller, it's a little bit of a different material. So essentially it will require a patch update that Hart will begin programming with the affected counties and jurisdictions and the affected equipment. Essentially, and the reason is because it's a different material, the system just needs to calibrate, essentially is the word I'm going to use, with the ballots and the ballot size, the material, et cetera. So again, this has gone through the EAC, it's gone through Pro V&V. I'm sorry, not Pro V&V, SLI, for testing, and they've also concluded again de minimis change. So happy to take any questions.
Anybody questions? Do I have a motion?
I move that the Board of State Canvassers approve the length adjustment due to page scan 4 scanner rolling end of life for the Verity 2.7 system used in the state of Michigan.
Support.
All in favor?
Aye.
Aye. Who's the normal business? We have other business presented to the board, and I think we do have some.
Yes, I have lots of updates. Well, not lots, but I have several updates. So, first I want, some of you may recall, we did engage in rulemaking about a year ago, I think at this point, for procedural rules to the Board of State Canvassers, as well as the recount rules, to update our recount rules, largely in response to some of the things. The recount rules were in response to some of the statewide recount that we saw in 2022, for example, and the procedural rules were largely timing and just kind of cleanups. Those were filed with the Department of State this week, meaning that they are now in effect. We will be sending them out to the members of the public, so they're aware. We will post them as well. The biggest impact with the procedural change is the requirement that people have to submit materials to the board at least 48 hours before the meeting. And that materials received less than 48 hours before the board meeting will not be allowed to be considered. We will get that out, but it is our intention that when we get something very last minute, that we will not accept it. I won't even pass it on. And I will respond and say, we're just rejecting this filing. It does not prohibit people from speaking. It does not prohibit members of the public from attending the meeting and testifying in support, opposition, just providing general public comment. It does not prohibit individuals even from reading from something if they want to bring like a letter and they want to read their letter. It doesn't prohibit any of that. But what we were aiming to go after was, if you recall, with the nominating petitions, when we were in May/June of 2024, when we had to have a separate meeting, when we were still getting literally 5 minutes before the meeting started additional challenges on petitions and rebuttals. And during the meeting, we were still getting emails. So it's meant to kind of prevent that from happening, to allow some sort of finality, to be frank, before we come to the board meeting. So like I said, those are in effect. They will and we'll put them out so the public knows, and we'll send them to the usual mailing list that we have, that we send the same materials to.
Welcome rules. That was a difficult time.
I do have a question for you. So if this letter that we received less than 48 hours ago would have been a classic example of something submitted that would not have been brought to the attention of the board.
That is correct.
So here's my question. I understand the 48 hours material will not be considered. And when we dealt with this before with nominating petitions, it was over challenged signatures. We had to go back to be verified by one of the QVF. The letter that we received less than 48 hours ago was an information letter. For you not to act on it as Bureau of Elections, I get it. But I have a different question. I'm concerned that we as a board should still be able to read it if we choose to.
Okay.
Is that within the guardrails of what's been set up, or is that at our discretion?
It's within, I mean, I can pass it to you as the board. What the rule specifically says is that members of the public shall submit material to the board at least 48 hours before the meeting. The board shall not consider material received after the 48-hour deadline. So you can pass it. I can still give it to you. I would, there's not much flexibility with the word shall, for that reason. And that's also partly why we are aiming as a bureau to push back our notice requirements as well. We've been posting agendas and things like that, no less than 4 days before the board meeting itself. So that way there is time for that. Same with like summary language, things like that. Staff reports are required to be posted 3 full business days at minimum. We usually do at least a week before the board meeting for that, for some of these reasons as well. So if we get it, I can pass it to you. I think you do have a little bit of restraint where if something comes in of what your limitations are, but that's where I would say that an individual that wants to do that, 1, get it to us before the 48-hour deadline, but 2, they can still come and speak to it. They still can come and say, this, I want to testify, and here's the materials that I want to testify on and speak.
And I'm not suggesting
Yeah.
that we would bend the rules on something like, for example, what we went through with the judge where the signatures kept coming in.
Right.
That's not even in my question. My question is more that if there's somebody submits a letter, if it's for information or if it sheds light. The sister question to this is I've been approached by a couple of folks who have asked, why are we not putting public comments on the website prior to the meeting? So if we've received public comments, why are we not posting those for people to read? And I'm not sure that's a legitimate question, but I'm asking it.
The main reason that we haven't been posting, that we typically don't post public comment on the website is because the public comment we get comes from a third party, right? A member of the public, things like that. And we just don't want to release anybody's PII, essentially, their personal email or anything like that. If they're submitting something to us collectively, whether it's the Bureau or the Board of State Canvassers, there's still that expectation of privacy, that yes, it's public comment, yes, they're testifying, but so we try to keep that back. If it's something the board wants us to consider, I'm not opposed to it. I think I would want to be clear because especially in instances where, like, you'll recall the last petition that we had over 400 emails roughly, give or take a couple hundred. That gets a little burdensome to go through and have to redact every single person's information. So I would I think there would be that balance if that's something that we want to consider.
We'll noodle on it for a while. Yeah. You good with that?
Yep.
Just, we'll come back to you with that one.
Okay. Okay. So that kind of leads me actually nicely to a couple of other things if we're talking about the website. We are working on just kind of updating the board's website in general to just make it a little bit more user friendly. We're working on getting some things out in just different ways to make it easier for both us and members of the public. And one of those things that we're working on is actually kind of a little bit more of like a branding element for the board so that things can have a very unique design. So we'll be bringing some stuff options essentially. We've talked about this before about doing more like videos or things like that. So this is just an example of things that we're trying to kind of have a more unique look to the board as well. So that's just kind of a update. I don't have anything yet, but when we have it, I'll keep you updated, as well as when the website changes too. So that might be a good time to even circle back to that to see what's an option. So not for today, but next meeting, we also are going to be presenting you with an updated copy of the petition manuals. As you might recall, we try to go through these at the end of each cycle. At this point, we are not proposing any change to the process. Right now, there's a couple of things we're going to clarify with the manual and the examples, and I think we're going to end up breaking them up into different versions. So it'll be like a statewide ballot question versus a candidate, just to provide a little bit of clarity for people, is one of the things we heard at the last cycle. So we are working on that. We're going to present those to you. My intention with that first was to ask if there was anything that the board process-wise wanted to change. I haven't heard anything since the last cycle, but I wanted to just double check. From here, we are intending on posting it and sending it to people to get public comment as well to present at the next meeting. But before we did that, I wanted to make sure that there wasn't something I've missed that the board is like, no, start doing this or stop doing this, something, and if there's anything like that. I don't need a firm answer on that. I mean, we can obviously circle back to that at the next meeting. But
I'm not sure if this is processed, but we had that lingering issue with regard to verifying the signatures of the circulators on, yeah.
that is part of what we're going to present to you as well. We have taken everything that we've done with the West investigation and have tried to basically reduce it to writing. So that way we've got a clear if this, then this. If you do this, this is what we need in order to kind of be sufficient. like a sufficient standard of proof, for lack of better terms, for us to commence an investigation. And then if we do that, this is what our steps are going to be. And then if you don't do that, and kind of have that step by step. So we are going to present that as well. We'll again post it online, but it was our intention to present all of that as one package. If you think of anything, I guess, in between, let us know.
Send it out.
Yes.
Yeah, the one thing that I had suggested and that I think you're working on is having the announcements a little more prominently displayed.
That's part of the general website overview. Yeah, so I'm looking at different ways to just make it clearer, like what's coming up on the meeting versus like a lot of the documents we have on our website are for like just resources for people, right? Voters, circulators, et cetera, petition candidates, sponsors, et cetera, of everything. So just to kind of delineate that a little bit better, that is one of the things we're working on. For lack of better terms, yes, where it can be a little bit like upcoming meeting, here's what's going to be discussed type stuff versus just, that is, yes, we are working on that. And then the last thing I want to update on is the West investigation. Yeah, I'm reading my notes to make sure. So we had intended to present a staff report to you today. The reason we didn't was largely because there is one circulator that we are attempting to get more information from. Largely in our review, and we will present this at the next meeting for sure, a staff report and with a request or a resolution, whatever. Largely overall, our review has concluded that there was no significant indications of widespread fraud like we've seen in others. As normal, there's a couple of signatures here and there that were determined not to match. There are some circulators that we still have not received information from. I believe there are 5, if I remember. Thank you. 5 circulators where we just haven't gotten anything from them. And then there was one circulator that we have received where we received a driver's license. It was an out-of-state driver's license, and his signature does not match the signature on the petitions. None of them. The signatures on the petitions all match each other, but they do not match the exemplar that was provided to us. And again, our standard of review with this it's all reasonable doubt, right, when we're verifying signatures. So what we are doing now is we are attempting to reach out. We have referred it to our Office of Investigative Services for assistance. I shouldn't say referred it, but we've reached out to our Office of Investigative Services to get some additional assistance to try to get a hold of this circulator. It's not clear to me whether this is fraud or whether this is a difference between the license and your regular signature. The reason for that is all of the petition circulator sheets, all of the sheets that this individual signed in the petition drive, they all match each other, but they don't match the license. So what's unclear to me at this very moment is whether is the license signature outdated? And again, because it's out of state, I don't have a way of telling whether it's a year old or 20 years old. I don't know that information. So that's kind of what we're trying to get more information on. We're trying to get some more information on whether this was this individual that actually signed these and the license signature isn't the most accurate, or is this something else? So it is our intention that we're getting close to to exhausting all remedies at this point. So at the next meeting, we'll have a presentation, we'll have the staff report, we'll give you examples, we'll show you kind of what we saw with the examples so you can kind of go behind us, for lack of better terms. And we will either have a resolution to this one way or the other, or we would be asking the board to take some other step. Michigan election law does contain a number of options after this that we are allowed to seek. So that's what we would be if we can't get information, or kind of, it'll depend on what the resolution is, but we will be asking the board to vote on something or to vote to close it, or some other action. So I didn't feel I could present that in a staff report today because the staff report is the final step, right? It's the final resolution. And I'm not prepared to say that this is or is not fraud. I don't know one way or the other. So, and we're just attempting to take all reasonable steps to reach that resolution. Yep.
What's the Office of Investigative Services?
Sorry, that is an internal office within the Department of State. That's the office we work with to, they relevant to this board was the office that we referred all of the previous circulators and signatures to be referred for criminal prosecution. So they help us with just basic investigations and things like that. They have a little bit more resources to be able to find people than we do. So that's why we looped them in to see if they were able to help us out a little bit more than we've been coming up with.
Right.
I think that's all of the updates I have. I know that was a lot, so.
Oh, no, I appreciate your updates. Those were all, we wanted to know about every one of them. So, is there anything else to add to the thing from the AG's office?
I was just sitting here trying to remember if the board is currently being sued, and I don't believe so. So let's enjoy that window while we have it, but
Feel ignored, or should we?
not at all. No, there's plenty of other problems in state government, I assure you.
If there's no other business to be brought before the board, I would say that we will adjourn the meeting. And we will adjourn it at 3:45. Thank you. You need a motion.
This one back, I already lost. I have too much paper. Oh, there it is. This one.
You did good. Yeah.
Nothing good.